Did you know the court is a rigged game, and they're counting on you being too scared or clueless to fight back? Here's the secret weapon they don't want you to know about: judicial notice. Stick around, because this one tool can flip the script and force the judge to play by your rules. The courtroom is a battlefield bout. The courtroom isn't a place for the unprepared. Let me keep it real with you. If you don't know the rules, you've already lost. The system thrives on your ignorance, your fear, and your silence. But when you know how to use tools like judicial notice, you can take back the power. Judicial notice is your shortcut to holding the court accountable. It's like throwing a wrench into their carefully scripted play. When you use judicial notice, you're not asking for permission. You're forcing them to acknowledge indisputable facts or laws. But let me warn you. If you walk into court unprepared, you'll be a sheep surrounded by wolves. Competence creates confidence, and confidence kills fear. Learn this, practice it, and take control of your case like the wolf you need to be. Part 1. What is judicial notice, and why it's so powerful? Judicial notice is a legal tool that lets the court accept certain facts or laws as true without requiring you to prove them. These facts must be: 1. Not subject to reasonable dispute, meaning nobody can argue against them. 2. Easily verifiable, like constitutional principles, statutes, or public records. Once the court accepts judicial notice, it's binding. The fact or law becomes part of the record, and the judge and prosecution can't argue against it. It's a way to force accountability and establish key points without a drawn-out battle. Why attorneys don't use judicial notice? Here's where it gets interesting. Most attorneys don't even bring this up. Why? Because they're officers of the court first. They're trained to play by the system's unspoken rules, not challenge them. They have no incentive to disrupt the status quo because their careers rely on keeping the court happy. That's why tools like judicial notice often fall into your hands as a self-represented party. You're not bound by the same professional pressures, which means you can use this tool boldly and strategically. Part 2. How to use judicial notice in real scenarios. 1. Fighting traffic violations with jurisdiction challenges. Let's say you're in court for a traffic violation. Most traffic laws are statutory, which means they apply to people engaged in commerce, like truckers or delivery drivers, not private travelers. Judicial notice can help you challenge their jurisdiction over you. What to say? Your Honor, I request judicial notice of Title 18 U.S.C. to require 31A6, which defines a motor vehicle as one used for commercial purposes. Let the record reflect that I was traveling privately and not engaged in commerce, placing this matter outside statutory jurisdiction. This forces the court to address whether the law even applies to you. If they can't prove you were engaged in commerce, their case starts to fall apart, forcing the court to acknowledge constitutional supremacy. Here's where judicial notice becomes a real game changer. Imagine the judge is prioritizing statutory codes over your constitutional rights. Judicial notice can bring the Constitution back to center stage. What to say? Your Honor, I request judicial notice of Article 6 of the U.S. Constitution, also known as the Supremacy Clause, which establishes that the Constitution is the supreme law of the land. Any statute or code in conflict with the Constitution is void under Marbury v. Madison, 5 U.S. 137, 1803. This puts the court on record as being bound by the Constitution, forcing them to respect your rights or risk creating an appealable issue. 3. Challenging the claim of an abstract injured party. If the prosecution claims the people of the state are the injured party, judicial notice can expose this as a legal fiction. What to say? Your Honor, I request judicial notice that the people of the state is an abstract entity and cannot testify under oath or show harm. For standing to exist, there must be a specific injured party present, as required by common law. This challenges their claim and forces them to provide a real injured party, which they usually can't. Part 3. How to file a motion for judicial notice. Filing for judicial notice is simple if you follow these steps. 1. Identify the fact or law. Choose something indisputable, like a constitutional provision, statute, or precedent case. 2. Write your motion. Include the fact or law you want noticed, the source, e.g. the Constitution, case law, or a public record, why it's relevant to your case. 3. Submit your motion. File your motion with the court and bring copies to the hearing. 4. Argue it in court. If necessary, explain why the fact is indisputable and relevant. Example: motion for judicial notice. Your Honor, I respectfully request judicial notice of Article 6, Clause 2 of the Constitution, which establishes that the Constitution is the supreme law of the land. I also request judicial notice of Marbury v. Madison, 5 U.S. 137, 1803, which holds that any law repugnant to the Constitution is void. This is directly relevant to my case, as the statute being enforced conflicts with constitutional protections. When you present it like this, you're forcing the court to acknowledge your argument without debate. What to do if judicial notice is denied? If the court denies your judicial notice, don't panic. This is just another step in the process. 1. Object immediately. Your Honor, I object to the denial of judicial notice as it violates my right to due process. Let the record reflect that this fact is not subject to reasonable dispute and is supported by specific source. 2. Resubmit your motion. If denied for lack of documentation, revise it and include certified records or additional evidence. 3. Preserve the issue for appeal. Every denial becomes part of the record, giving you grounds to challenge the court's decision later. Closing thoughts. Be the wolf, not the sheep. Let me leave you with this. The courtroom is a mental battlefield. If you're unprepared, you're a sheep. But if you've memorized your defenses, mastered your objections, and know how to use judicial notice, you're walking in as a wolf. Like Sun Tzu said, victorious warriors win first, and then go to war. The time to prepare is now. Learn this, practice it, and when you step into that courtroom, own the battlefield.